May it please the court, Clayton J. Perkins appears on behalf of Alejandro Arturo Garcia Garcia. I would request 2 minutes for rebuttal.
2 minutes is granted.
In terms of a short summary of the underlying facts, this case is a direct appeal from a jury trial that resulted in the conviction of Mr. Garcia of attempted capital murder of Deputy Michael Grimes, the kidnapping of Stanley Schaefer, a burglary, and interference with law enforcement. The underlying facts started south of the Kansas border in Oklahoma when Mr. Garcia was driving a Tahoe that was pulled over by law enforcement and fled from that stop. A high-speed chase followed, during which a passenger in the Tahoe, referred to as Cesar, shot at law enforcement officers that were following. Ultimately, one of those officers in Oklahoma was hit by Mr. Cesar's gunfire and had a severe traffic wreck. Mr. Garcia continued driving north to the Kansas border, where the Tahoe passed over spike strips that disabled the vehicle, and the occupants all fled on foot. Mr. Garcia ended up at the home of Stanley Schaefer and asked him for a ride. Mr. Schaefer eventually gave Mr. Garcia a ride to what he thought was a gas station. Their communication was difficult because Mr. Garcia did not speak much English. Eventually, Mr. Garcia had a gun pulled out and told Mr. Schaefer to keep driving, and Mr. Schaefer understood it to be trying to get him to drive to another city. Mr. Schaefer, however, stopped his truck at the border of the city he was in and got out. Mr. Garcia then got another ride from a nearby driver to another town north of there. While that was going on, Deputy Michael Grimes was responding to the scene of the crime, spotted this new car, which had been reported by Mr. Schaefer to 911, and followed it to another town and then through another town, where it stopped by a highway that Mr. Garcia had asked this new driver to keep driving him to. Mr. Garcia got out. He had a gun that Deputy Grimes saw, and they exchanged gunfire. There was a dispute over whether Deputy Grimes shot first or Mr. Garcia shot first. Deputy Grimes was not shot during this, however. All of the gunfire was directed towards each other. Mr. Garcia fled to a nearby home that was unoccupied at the time and hid there until he was captured by law enforcement. Proceeding to the issues of the case, the first one is dealing with the relevance and probative nature of the information in Oklahoma, particularly the information about the injured officer getting shot.
Counsel, just
Yes.
back up a second, just for sequential reasons. Do you have anything to add on the jurisdiction question?
I do not believe I do. I think the state and I are in agreement that jurisdiction is proper in this court following the amendments to the attempted capital murder law to make it a off-grid crime.
And just a quick factual clarification before we move into the issues that may or may not make a difference, but when Mr. Schaefer was driving the truck and then suddenly, once he saw his friend fishing or something, he got out. What were the circumstances? Did he just leave? Did he bail? What occurred there? It's not clear to me. Was it just a voluntary leaving the truck?
He stopped the truck. He got out and spoke to his friend who was at this bridge fishing. Mr. Garcia was still in the passenger seat at the time. At some point in there, Mr. Schaefer went back and took the keys out of the truck because I think he thought that Mr. Garcia was going to take it. And yes, They spoke. Mr. Schaefer called his father on the phone first before he called 911 to try to figure out what to do.
Okay, thank you.
But the bottom line is he just took a chance and got out of the truck. If you believe his testimony that he was fearful of the gun, he just decided, this is what I'm going to do. I'm going to stop the truck and get out. And Garcia didn't do anything to prevent him from doing that.
Correct.
Okay, thank you.
So in discussion of this first issue, there is the state and I kind of discuss the differing standards of whether this is 6455 or relevant and probative versus prejudicial, which framework this is argued under, because procedurally it was argued under both through pretrial motions and a motions hearing. But the core of both of those is that the evidence about the officer getting shot, that the car flipping, the actions of his partner in pulling him from the vehicle, all of that information was irrelevant to the case and highly prejudicial.
Why was it irrelevant?
It was primarily it was irrelevant because there's no information that Mr. Garcia was aware of any of it.
But you didn't make that argument to the district court.
That I believe that argument was made to the
Where
district.
I've got the motion in limine and the hearing transcript here, and I went through it again last night, and I don't see where there's any claim that this information isn't relevant to the motive and intent aspects because the defendant wasn't aware of it. You say it wasn't relevant because it was going on in Oklahoma, or not you, but counsel below. But but I just don't see where you connect those dots to the argument you're trying to make here, and the reason I ask is because the state says you haven't preserved it.
Yes, absolutely.
So just where in the transcript or in the, I don't care which one, but where in the motion or the transcript do you make the unaware argument, if you will?
Well, and it's I look to sort of Mr. Wick's last bit. I think it's on pages 49 and 50 there, where there is some overlap here between the distinct relevance and the prejudice argument. But he tells the judge, if this is coming in, this is basically putting whether or not Mr. Garcia was aware, which was the Oklahoma crimes at issue in all of the case. And that is...
We've got a constitutional argument about making him talk about something that he's charged with in Oklahoma, but that doesn't make an awareness argument. That's where I'm not connecting your defense of the preservation argument. You see what I'm saying?
I think I do. And, well, I guess there's sort of two things. First is that this is a ruling on both the defense's motion in limine to exclude and the state's motion in limine to include this for motive and intent. And part of this is that this appeal is from the district court's ruling that this evidence is relevant to motive and intent, and that this evidence was part of the state's proffer, so all of the evidence the state proffered was subject to the district court's ruling. And so I'm arguing that it was not relevant for the...
The question is whether you're arguing it's not relevant for a new reason than what was argued before at the district court, because if your argument is he wasn't aware of it, the district court didn't have an opportunity to chime in on that claim.
I believe the district court did have an opportunity to address all of that. It was presented in the state's proffer that about the officer's injury and the wreck. And the state said this was relevant for motive and intent, and the district court ruled that this is admissible and relevant for motive and intent.
Was it ever raised that your client was not aware of the underlying action? Act 6455 evidence was offered for. I mean, you're claiming that he wasn't aware. Isn't that what you're saying, right?
Yes.
That he wasn't aware of it. And was that articulated to the district court either by the state or it's certainly in defense? Did the defense ever raise that he wasn't even aware of what occurred?
Yes, I believe they did in that motion hearing. They were arguing that basically, in a general sense, they were arguing that it was irrelevant, but it was irrelevant because the state was trying to prove an Oklahoma crime that they didn't have evidence for. And that was leading to all of.
Well, your
Excuse me.
client was present at the Oklahoma crimes, wasn't he?
He was present, yes.
So, okay.
Are you saying that the pursuit by the Oklahoma officers was admissible? It just up to the point where the troopers had the accident, the flip, and then that's where you cut it off? Or I'm not sure I understand what lines you might be trying to draw.
Yes, for the purposes of this appeal, I have tried to limit the argument presented to the district court to the portions that were, I believe the district court was unreasonable in finding relevant. And that is that the state could admit evidence that Mr. Garcia fled and that he knew that Ms. Cesar was shooting at the officers. And that, I believe he said, Cesar told him he had hit one of the vehicles. I do not believe that the information about the officer getting hit, swerving off the road, flipping, and the retrieval by another officer was relevant to prove anything at issue in this trial. It was also argued as highly prejudicial, which I think there is some overlap there, because even assuming there was any probative value to this, it is extremely minor. It is extremely prejudicial that the injuries to this law enforcement officer, the panic and terror that his partner went through, all of that information had very little that I can see to do with the facts of this case, but it went before the jury. And then it also went before the jury as directed to motive and intent. And I think the state, what they wanted was for the jury to say, well, there's a previous attack on a law enforcement officer, and Mr. Garcia is fleeing from another attempted capital murder, and that gives him motive to premeditate the killing of Deputy Grimes. And that is not a reasonable inference to draw from that, and it's highly prejudicial.
Is it a reasonable inference to draw up to where you want to say it is relevant? I mean, observing, engaged in a fleeing from an officer with a passenger shooting at a vehicle, wouldn't that serve the interests of motive and intent?
Yes.
Up to that point?
Up to that point, yes. Yes, or at least
it's arguable anyway.
yes. I wasn't arguing the district court was unreasonable to that aspect of it.
Up to that point.
Yes.
Let me move you over to the prosecutorial error claim while
Yes.
you've got some time. And I'm specifically talking about the prosecutor wanting to talk about reasonable doubt, where we know every time they do that, they're in a minefield.
Mm-hmm.
Do you believe that what the prosecutor said in any way altered or lowered the reasonable doubt burden that the state had in this case? I mean, what I see him saying is there's a two-part test. One is whether you have doubt, and the other is whether it's reasonable. And the judge is going to tell you what all that means because the lawyers can't. That's what I see the prosecutor doing. And I can't see an impact to that, regardless of whether it was a wise thing to do. I don't see an impact to the state's normal burden of proof. Do you?
Yes, I do. And I think that the part of it is that there's a certain level of what is reasonable doubt that should not be defined beyond what the jury's understanding of it is. And I think that there's sort of multiple ways that different jury members could think of reasonable doubt. One is the way the state articulated, but there are also ways that include sort of a totality look at the case and whether just concluding, do I have reasonable doubts about this case? And individual in any aspect of particular crimes. And that is different than sort of a 1-2 operation of I consider an individual doubt, I consider whether it is reasonable, and then if it is not a reasonable doubt, I exclude it. And so I think that does, by framing it that way and directing the jury to think of it in that regard, it changes things.
It eliminates a holistic view of the case. Is that what you're saying?
Yes, or of individual crimes. At least.
Okay.
And I see that my...
I have one quick question.
Yes.
Was there ever a discussion of res gestae in this case below on the question of 455 evidence?
I don't think res gestae was specifically addressed.
Should we think about it because of our case law, State v. King, recently in Butler, where we emphasized that 455 doesn't even apply within the res gestae of the crime? The, quote, evidence relating to crimes or civil wrongs committed as part of the events surrounding the crimes for which the defendant was on trial.
No, I don't think that this is a... At least as I was looking at res gestae and the state's briefing of it, I don't think it's really a... I go back to that res gestae is not an independent basis to admit evidence. Evidence can be relevant, and other crimes evidence is subject to 455. But this was other crimes evidence.
Well, we have case law saying 455 does not apply to any other acts that are part of the res gestae of the crime. Certainly the other rules of evidence do apply, but not 455.
Yes, and I guess that's why sort of with this regard, there's the overlap between the relevance arguments, the probative versus prejudicial arguments, and...
Yeah, so you would be making those same probative versus prejudicial claims, even if it's not 455 evidence.
Exactly, yes. And with that, I would ask, consistent with the issues that I submit on the brief and the issues discussed today, that this court reverse Mr. Garcia's convictions and remand for new trial.
Thank you, counsel.
Morning. May it please the court, the appellee, State of Kansas, appears by Stephen Obermeyer, an Assistant Solicitor General. If I could, I'll address the same two issues as my colleague, and if I could do them in reverse order, starting with the second issue. As far as the discussion on reasonable doubt, this court does not see the cases where a juror says, well, I think the defendant did it, I just didn't think so beyond a shadow of a doubt, or words to that effect. And so the questioning in voir dire is relevant because both parties, the state and the defense, are entitled to a juror who will apply the correct burden of proof. The defense doesn't want something less than beyond a reasonable doubt. The state does not want beyond a shadow of a doubt jurors to think that. So I think the questioning by the prosecutor was fair to set out that that you have to find beyond reasonable doubt. In this world, nothing can be said to be certain except for death and taxes. And so I think there's doubt about everything, as was discussed with the prospective juror, doubt about whether I'm marrying the right person, things like that. But it has to be beyond a reasonable doubt. And so I don't think that met the first prong of the test as to that issue.
What if we assume that you're wrong? Can you talk to the issue of reversibility?
Sure. And I would direct the court to State versus Akins, which was a case where the trial judge, during jury orientation, thought that he misstated to the panel the standard of the burden of proof. And that was an issue on appeal. And the court said this was a 2-week trial. The jury was instructed directly before closing arguments, and they would have followed the jury instructions then and not said, well, wait a minute, back 2 weeks ago the judge said this during jury orientation. In this case, the prosecutor said, I cannot define reasonable doubt for you. So the jury is told that. And the jury is instructed that you have to find the elements beyond a reasonable doubt. So I think if the court does disagree, which I hope it would not, that it's a harmless error issue. With regard to the first issue,
While you're on the prosecutorial error, can
Sure.
you address the harmlessness as you would see it of the other statements by the prosecutor?
sure. I think when we talk to the jury about hypotheticals, about what a party could have done, should have done, that's different than in State versus Henry, talking about Mother's Day was yesterday, and you should find the defendant guilty because the victim's, the mother's deceased. Or in McCaslin talking about roasting a fire or something like that. I think that's different from here just trying to make the point that Garcia had options. He could have stopped when the officers, said get out of the car. The statement when he was given the gun, he could have shot. I don't think that helps the state to think that you should have shot Cesar. I don't think that helps. But the point that was trying to be made was that he had options, but he was a desperate man who wanted to get away from what had happened in Oklahoma, and his actions show that. So I would say that if the court thinks that was error, that it would, just given the evidence presented at trial and the fact that the jury is instructed to disregard statements of counsel that are not supported by evidence, that would amount to harmless error.
Would you agree it misstates the law and by implying that the defendant had a duty to retreat or to shoot his partner in crime, and that
Does it misstate the law?
misstated the law in doing that?
I don't think he would have been justified in shooting at Cesar, but I think the point when we look at the closing argument in context was the entirety in context was that Garcia had different options, and the attorney goes on to list several different options that he doesn't avail himself of when he ends up with a shootout with Deputy Grimes, and that was what the jury was there about, was the shooting back and forth, and not the fact that he didn't stop Cesar from shooting, I think.
So is it error or not?
I don't think
it's
it's error.
not, the state believes it's not error to suggest that the defendant should have turned around and shot his co-defendant in order to prevent the law enforcement officer from...
I think it was the hypothetical on that there were options that could have been done. I don't think this state was really advocating that Cesar should have been shot there.
Sorry, counsel, how different, if at all, is this comment from a prosecutor saying once the defendant got the gun, he could have held it on Cesar and they could have surrendered together? Do you see any difference?
I don't see much of a difference, because the point is still that he had other options that he could have done other than what he ended up actually doing. And again, I think it's different than talking about real life victims and victims' families, where you have this prejudicial impact versus kind of hypothetically talking about what could have been done. And I would put it in that realm.
Well, the argument, as I understand it, on the comment actually made is that it was suggesting that the defendant had a duty to shoot his co-criminal, if you will. But does the same argument apply to the hypothetical I posed? And that is, does it suggest that the defendant had a duty to pull the gun on his colleague and say, we're surrendering?
Um, I guess he didn't have a duty to do that. If he was an innocent person caught up with a bad guy in Cesar, he could have certainly done that. But I do think that it's a similar type of argument, and if the state had said that instead, that would even be less of an issue, I would think. And again, the point was to show that he had options, but he was aligned with Cesar and trying to get away from that situation, and that's why he, took Schaefer and the Good Samaritan who picked him up at the river and had the shootout, I think. So,
Thank you.
going to the first issue, unless there are any questions, I would say that as the attorney who was a attorney on the case on State versus Gunby, I was thrilled to see the later cases defining what res gestae was, because that language in Gunby really wasn't res gestae evidence. It was prior chokings of a girlfriend, and the judge used that term in making a ruling, but it wasn't the events surrounding the crime in Gunby, and the court has since.
Do we need to use that? Why don't we just use the language of the statute, 6455, that talks about evidence that a person committed a crime or civil wrong on a specified occasion, and then it goes on that you can't use it as the basis inference that a person committed another crime or civil wrong on another specified occasion. And the plain language contemplates two separate occasions. And if we say that this is all part of one occasion, why can't we just say it's not 6455 without getting into all the baggage that res gestae has carried from Bly on forward?
Sure.
Right.
I think you could.
It's the
you
same
could-
concept.
It is the same concept. Res gestae just shows that you went to law school. But otherwise, I think you could say it that way. But the third step of the 6455 standard, the prejudice versus probative value, is the same as the analysis under 6445 anyway. So I think that's where we end up on issue one, assuming that we're going to fault the district court for not predicting that we're going to parse out some of this evidence on appeal, and that shouldn't, and say that shouldn't have come in. So the probative versus prejudice standard of review is abuse of discretion, and I think a reasonable person would agree with the district court's ruling that that evidence would come in. We had Cesar actively shooting at a police car. Cesar saying that I think I hit one of the cars, and then what happened after that.
Just so I can understand your position, it sounds like your position is that we do have in front of us, and we do have to review the lower court's probative versus prejudice analysis and determination. But any of the other decisions the lower court made with respect to 455 are irrelevant. They don't have to be reviewed because this isn't 455 evidence. Is that your position?
Yes, I think so. I mean, they went through a 6455 analysis
Right, they
in
did
the
it.
district court.
I'm just asking what your position is
Yes.
in terms of should that be reviewed? Does it matter?
I don't think it matters, because I think you had the first two steps of 6455, and both 445 and 455 have the prejudicial versus probative, and so I don't think that it matters. Yeah. I don't think I have any other arguments on any of the other issues, unless the court has any questions.
I see none. Thank you, counsel.
Thank you. I'd ask you to affirm the defendant's convictions. Thank you.
As a first point, they're going back to this discussion of relevance and prejudice versus 6455. I think this case, it ended up being submitted in the sort of right manner regardless to the distinction, because they noted that there at least could be a 6455 issue here and proceeded to address it under that framework, which I think provides many of those protections. The problem, however, is that the protections still allow, or that framework failed in allowing this highly prejudicial evidence to come in, and that it was implied that it could come in for as evidence of motive or intent, which would mean Mr. Garcia knew of it when he did not. And to sort of generally discuss prejudice in this case, the evidence here of premeditation to the attempted murder of Deputy Grimes was not overwhelming. It's hard to point to individual facts in the record leading to premeditation or an inference thereof. And for those reasons, I think the errors in this case require reversal of Mr. Aguirre's, or Mr. Garcia's convictions. And that concludes my prepared remarks.
Any questions? All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.